SC section 1247. That is your paramount code section. You don't have to be able to quote it. I'm an attorney. I know how to find these things. All I'm going to tell you is it's called the National Trail System Act, Steve. Interim use of railroad rights of way. Okay, that's your ending. 1247, subparagraph D. Add the parentheses D to your note. All right, Steve? Here is the operative language and why this is so important. The National Trail System Act dates all the way back to about 1968. Rail banking was added to the law in about 1983, and here's the important part. While a railroad when a railroad decides it does not want to use a corridor anymore for any number of reasons. Number one, it's not profitable. Number two, you think of it, whatever. What was happening is after World War II, we started losing so much railroad right-of-way and train service that the federal government thought it best that we do something to preserve these railroad corridors so that if any time in the future, say a national emergency, catastrophe, somebody needed to come in and get rail service to a large degree back in place. They wanted these railroad corridors preserved. So they created the rail banking system. What that simply says, a railroad can take its right-of-way, and if they don't think they need to be using it anymore, they're not going to abandon it. They are going to rail bank it. They're going to put it in the bank. And they do that by filing something with the Surface Transportation Board, and you'll see the numbers here in just a little bit as I go through this. The Surface Transportation Board in Washington, D.C., and what they do is they say, look, we intend to discontinue use in this system on this stretch of track. And they will file the necessary papers. And under the law, for 6 months, anybody can come in and say, okay, you want to abandon it? Well, while you are not using it, we want to take it and turn it into a public recreation area. The concept is called a linear park. Linear park. How many of you heard of the Blue Ridge Parkway? How about the Natchez Trace Parkway? Guess what? Those are public parks. What is unique about them? They are linear parks. They may only be this wide, and they may go for hundreds of miles, but they are public parks. Now, when this person, and I'm just saying person, it could be an individual, could be a corporation, could be a city, state, could be a nonprofit organization, when they come up and say, okay, we don't want to lose that right of way, so what we'll do is while you're not using it, we will take it and preserve it. And we will file something to say we'll keep it in the rail banking system. And if nobody picks it up, what has to happen to it after that? Surface Transportation Board will actually let it go away if nobody picks it up. But who's in Washington, D.C. to pick up every one of them? The Rails to Trails Conservancy. And that is exactly what has happened in Bowie County and Red River County, Lamar County. Well, Rails to Trails didn't pick theirs up. And in
Greater Parish Development Foundation.
Yeah, Greater Parish Development Foundation. What happened in our end, and I'm mostly speaking to our folks, what happened on our end is the Rails to Trails Conservancy picked it up just to preserve it. And then they came to Bowie County, they came to the City of Avery, City of Winona, City of Clarksville, and said, look, we saved it as a public park. Now, we need somebody local to come in and make something of it. Okay? But here's the operative fact under the law. As long as that trail is being used on an interim basis, and that's a legal term, interim use, read this. Such interim use shall not be treated for purposes purposes of any law or rule of law as an abandonment of the use of such rights of way for railroad purposes. In other words, just because the railroad, and when I talk about the Supreme Court case, you're going to know what I'm talking about. Just because the railroad said, look, we're losing money running these lines, but we don't want to lose the corridor. We want somebody to pick it up for us. As long as they file everything properly in Washington, D.C., and somebody picks it up and does it properly on that end, has the railroad abandoned the right-of-way? No, not under the law. Which means all these landowners who want to say, well, the railroad abandoned it. No, the railroad didn't abandon it. The railroad railbanked it. And as long as it's railbanked, and it was done properly, the fact that the railroad is not running rolling stock up and down tracks that are no longer there, the ballast has been removed, it doesn't matter. It says that as long as it's being used in the interim under the law, allowing rail banking, that the fact that the railroad is not running cars on it anymore is not a legal abandonment for any purpose. Now that's the law. And this is the rail banking. This is what gives us what we have out there on the ground. Now, Steve, you take the next one. In Red River and Bowie County, you can mark this down. Now here's the thing. I've asked for it, it hadn't been given it yet, but everybody has to go through the same thing. But in Red River and Bowie County, there's your number. Surface Transportation Board docket number AB-3, sub number 137X. Folks, you can go online and find every one of these documents. These are public documents. You can find them online. It's public filings with the Surface Transportation Board. Now, what happened in 1997 when the railroad first offered it for rail banking, the RTC submitted a statement indicating its willingness to assume full responsibility for management of, legal liability for, and payment of taxes on the rights of way as required by blah, 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 blah. Every trail manager, and at one time it was the RTC, now it's who I said, Bowie County, Avery, Anona, Clarksville, Greater Parish Development Foundation, and Chaparral Trails. Every one of them had a signed document saying they're going to do three things. Who can tell me what they are? Preserve and, well, first of all, develop and maintain that right-of-way for public recreational use. Number one. We are fortunate in our 132-mile system to have this effect. You either choose to preserve it for motorized use or non-motorized use. Thankfully, for our 132 miles, guess what ours is from one end to the other? Non-motorized, which means hiking and biking. And horse. Not yet. Not yet. Hiking and biking. As opposed to four-wheelers, ATVs, dirt bikes, etc. Okay? Ours is hiking and biking. That's the way it was filed in Washington, D.C. Everybody signed up to agree to that. Fine. Now, before I go any further, let me address how horses come in. Equine use is not under the statute. Okay? Under the statute, there's only three possibilities. Motorized on one side, hiking and biking on the other. However, under the regulations that were adopted for the rail banking statute, it is under the regulations that says equine use is a compatible use with hiking and biking. Nothing is compatible with motorized. And that's why there are so few motorized rail-to-trail projects. Why? Because if you pick motorized, you don't get to let anything else on it. But if you pick hiking and biking, you can then add horseback in places where it's appropriate. And that's how horse folks get involved, okay? Now, that's the first thing that has to happen. You have to say that you're going to develop it and maintain it for what? Public recreation use. That means you're going to turn it into a park. You're going to turn it into a linear park. You're going to protect it as a linear park. You're going to offer it to the public as a linear park. See? In 2000, Rails Trails Conservancy signed their agreement, and Ann, you can verify this. This one shows Bowie County. Steve, go to the next one. As to that agreement, the city of Clarksville signed one just like it. The city of Winona signed one just like it. The city of Avery signed one just like it. Greater Parish Development Foundation signed one just like it. Chaparral Trail signed one just like it. Okay? Use of property transferred to the county. The county agrees to develop and use portions of the property described in Exhibit B, which is the railroad right-of-way, for public, trail, and recreation uses consistent with the National Trail System Act as amended. Folks, I didn't hold a gun to anybody's head and make them sign these documents, but they signed them. So now you got it. You have a park out there, and you have to make it available for the public. Go ahead, Steve. You're doing it under the requirements of the National Trail System Act. I'm fixing to cover the other two in just a minute. Any development thereon must be consistent with the requirements of the National Trail System Act. Go ahead, Steve. The county agrees to undertake all obligations presently assumed by RTC in its capacity as that is a legal term, folks, under the law, trail manager. RTC had the entire length from the edge of New Boston all the way to the west side of Clarksville. They were the interim, what? Trail manager. Now that each of those entities have signed agreements with the RTC, guess who the new trail manager is now? Each of those entities. All right, Steve? Well, there's Bowie County. Folks, these are public records. I didn't have to go dig them up somewhere. These are public records. Our county signed up to say, we're going to make this a park. We're going to make it available to the public. We're going to protect it for the public. We're going to treat it as our property. All right, Steve? This one, City of Clarksville. A little different wording, but the concept is the same. Let me tell you the other two parts about the agreement. You remember one of the documents back, it said it had to agree to be financially responsible for all liability? In other words, the railroad ain't going to get sued if somebody gets hurt out there. When you sign that document, I believe I have one in here, it's called Statement of Financial Responsibility. You agree that you're going to hold the railroad harmless if somebody is out there on your property and gets hurt, you're responsible. Okay? That's the second prong of the three-part requirement. Go ahead.
Is it any different, though, with somebody getting hurt out on the street? Is there any difference?
No.
So it's just adding one more street to a million streets already there.
Yeah. I mean,
As far as liability goes.
as far as liability goes. Now, municipalities and counties can hide somewhat under sovereign immunity. But who wants to be the test case? Let me tell you this. Nationwide, there is a strong movement, has been for a long time, a movement to remove sovereign immunity from public entities because so many times people had grotesque injuries and deaths. And it was because government employees just say, hey, it doesn't matter, they can't sue us. So every state pretty much has had test cases where sovereign immunity was either removed altogether or greatly reduced. Now I'm going to tell you something. This is about Bowie County, and the reason I know this is because of how long we've been working on this. It took me forever to get our county to understand the documents they signed. And we had a bridge out here. How many of you heard of Holy Bridge? It was called Holy Bridge, and there's pictures on Facebook and some of our stuff. Holy Bridge, I'm telling you, it was holy. And that's why it was called Holy Bridge, because it had some gaping holes in it this big. And the thing about our trail, and one of the reasons Bowie County didn't have that much trouble getting ours in good shape out west of town, is because everybody was using it. Now, it was being used by four-wheelers, ATVs and horse people and hikers and bikers. There was no control over it, but at least it was being used. And you would not believe some of the contraptions people would put out there on Holy Bridge to keep from breaking. Can you imagine somebody who's not from this area and not familiar with Holy Bridge, and it's getting late and they're on horseback and they go flying down that trail, and that little 10-year-old girl and that horse steps in that thing and breaks its leg and crashes and burns, and that little girl's a quadriplegic. She goes to court, and she's sitting there, a little 10-year-old girl in her wheelchair, her blow through the air thing to get her to move wheelchair. Do you think Bowie County's going to come out pretty good with a jury sitting there wanting to make sure that they can get sovereign immunity removed so somebody can be held responsible for that girl, especially when everybody knew the condition of that bridge? There's no way the county could say, well, we didn't know it was in that shape. That's how I said, you signed a document that said, we understand we are the financially responsible party. We are liable for whatever happens on that trail. Okay. That's the second prong. The third prong, and you'll see that in just a minute, the third prong is you acknowledge that at any time in the future, if the railroad wants to come back and reoccupy that right-of-way, you have to be willing to give it up. That's why you don't see 10-story buildings built on these rights-of-way. Nobody's going to invest that kind of money. But don't think it's that big of a danger, because less than 0.5% nationwide of all the railroad corridors that have been Railbank, less than 0.5% nationwide have ever been reoccupied by the railroad. Okay? Now, I'm just telling you, at some point in the future, some catastrophe may befall the United States where we're going to all need those railroads to reoccupy and turn back on. Okay? But it hasn't happened yet. Earl?
But Keith, also, if that were to happen and the railroad were to come back, there's enough room on that 100-foot corridor to put a shared trail and a railroad back in. So
There you go, Earl. So it's not that big a danger that if you do trail development, if you put bathrooms out there, if you put rest stops, if you put parking spaces for people to have places to park to come get on the trail, you're not likely to lose your investment. Your investment's not going to be in any danger. However, under the law, that is one of the requirements, is that you took the trail with the understanding that you have to give it up if the railroad ever says we need it back. Steve? Now again, this is the city of Clarksville. And Ann, I'm going to ask you a very simple, real quick question. The city of Clarksville signed the same document the city of Anona did, signed the same document the city of Avery did, correct? Okay. That's why I don't have all of them up here. I've just got representative ones that I'm using in the city of Clarksville. Property for public, trail, and recreational purposes consistent with the National Trail System Act as amended, blah, blah, blah. Whose does that sound like? Sounds just like Bowie County. Well, guess what, folks? They all sound this way. It's the law. The forms are uniform. You can find them and read them for yourself. Go ahead, Steve. Joint motion of Rails to Trails Conservancy, Bowie County, Texas, for what? Substituting Bowie County for the Rails to Trails Conservancy. It was done. It was approved. Bowie County became the interim trail manager from the West Bowie County line to where New Boston stops. See? Under its agreement with the RTC, Bowie County agreed to use the corridor, quote, for public, trail, and recreational uses consistent with the National Trail System Act, blah, blah, blah. Folks, it's the same language. It's consistent throughout. It is supposed to be a public trail. It's supposed to be there, created and maintained for public recreational use. See? Here we go. Statement of willingness to assume financial responsibility. And did y'all sign this document? And to the best of your knowledge, the City of Anona and the City of Avery signed one just like it. Okay. In order to establish interim trail use and rail banking, Bowie County, Texas is willing to the extent permitted by law to assume full responsibility for management of, for any legal liability arising out of the transfer or use of, and for the payment of any and all taxes that may be levied or assessed against the right-of-way in the above captioned proceeding. Every trail manager had to sign that document. And they did. It's in Washington, D.C. See? Bowie County acknowledges that the use of the right-of-way is subject to the user continuing to meet its responsibilities described above and subject to the possible future reconstruction and reactivation of the right-of-way for rail service. There's your third prong. And is it signed? Yes, it is. James M. Carlo, Bowie County Judge. Hey, Steve? And then there's the quitclaim deed. Now, here's where I need to do some explaining because I want to tell you why the recent Supreme Court case, U.S. v. Brandt, did not hurt us, and it didn't hurt any other trails that were properly railbanked. Steve, go ahead. All right, this was in the deed. Grantor acquired such right, title, and interest as grantor may have. Now, what did they have? Did they have the dirt? No, they didn't have the dirt. They had the right-of-way on the dirt. Okay? But again, where's the phrase? For public, trail, and recreation usage consistent with the National Trail System Act, blah, blah, blah. I'm sounding like a stuck record. But that's what the law says. And that's what everybody signed up for. Okay? Go ahead, Steve. And that is out of the very deed that the city of Clarksville signed. All right. Pause a second here. Here's where we're going to stop. I'm going to cover that. I'm going to cover that because that's very important. Everybody watch your eyes. Okay, let's talk about the U.S. v. Brandt Supreme Court case. When you say you own a piece of property, okay, you're thinking in terms of I can go out up there on that dirt and I can dig me a hole, I can plant me a tree, I can put a fence in, I can build a house on it. I own this property and I'm thinking I own the dirt. Okay? Well, it's actually more than that. Think of it as a bundle of rights. Think of it as a bundle of rights. When I say I own a piece of property, there are a lot of rights under the law that I have if I actually own that dirt. Okay? Now, what's an easement? An easement is where I may take one of those rights and I may give you all of that right, or I may open it up and unroll it, and I may cut it in half and may only give you part of that right. Okay? Well, that's an easement. Just think of it as this. I own the rights. If I truly own it, I own this bundle of rights. When I give somebody an easement, I give them part of those rights. And that's all I give them. Okay? Now, in the rail banking system, and you can rest assured just about everybody who ever gave the railroad a right to put a railroad in it, they said if you ever abandon it, it's going to come back to me. Okay? Well, if it's properly rail banked, what did the law say about that act? It's not an abandonment. It cannot be, under the law, considered an abandonment for any purpose. In other words, the railroad's still using it. It's just that the trail manager's using it for them for a period of time. And so that bundle, that partial right is still out there. Now, let me tell you what happened in the U.S. v. Brandt case. In the U.S. v. Brandt case, the federal government gave the Brandt family a long time ago some land. And they wanted them to give the railroad a right to run a railroad through there. Because remember, what was the wide open West back then? It was wide open. And land could be bought for a penny an acre. Okay? So the U.S. government patented the Brandt family thousands and thousands of acres. And a railroad came through there, and they took an easement so they could build a railroad through there. The railroad in this Supreme Court case did not take advantage of the rail banking system. They simply abandoned it. They just literally walked away. They really did abandon the right-of-way. So under the law, which is a common law, very common in every state, what happened in that case? that partial bundle of rights that I handed off to somebody else, it came back to me, and then it unifies back in me. Okay? The federal government, we won't go into anybody's political persuasions, but the federal government just decided on its own it's going to go turn it into a public park. So the Department of Interior, after a few years of it being abandoned, they just went in and started building a Bureau of Land Management park. And the Brandt family said, wait a minute. No. And that's truly what that Supreme Court case was about. Our government just literally didn't follow the law. They didn't have a right to build the park and go in and start putting signs up and campgrounds and things like that. Why? Because it was never Railbank to start with. There was nothing preserving the corridor. Okay? Does anybody not understand what I just said compared to what I was saying a while ago? Everybody good on that? That's what I wanted to make you understand. The Clarksville paper, she did a great job of writing the article. I don't know why she had to quote the one lone dissenting judge. She could have quoted the 8 that voted correctly. But I publicly said the decision was correctly decided. Because the law is that if an easement is truly abandoned, it's abandoned and it reverts back to the owner of all those interests. That was correct. But is that the situation where we are? No, it's not, because I have read every one of these documents. I have not read Chaparral Trails. I've not read Greater Parish Development Foundation. But I'm telling you, we are Railbank. We are Railbank properly. Surface Transportation Board has issued its proper orders. They're on file. So, as far as the bundle of rights that was handed off to the railroad and then taken in by the RTC, and then eventually taken in by Bowie County, City of Avery, City of Winona, City of Clarksville, Greater Parish Development Foundation, and the Chaparral Trail, the right-of-way, the right to use that right-of-way and make it a public park exists and it vests in those entities. It's that simple. Go ahead.
Pete, I understand what you're saying, but we've got landowners out there right now that look at that case. They don't understand it, but they're saying, we're not going to have to move our fences. You know, we're still fighting that battle.
I understand. And it's just a matter of they're not going to listen until... Here's the thing. Greater Parish Development Foundation challenged everybody that challenged them. They said, we're coming through, and if you don't think we're doing it right, take us to court. Well, every landowner, and Earl, you can testify to this, every landowner that threatened to go get an attorney, what they did was they went to see an attorney, and then he starts studying rail banking, and he says, that's a battle I don't want to try to face. That case is not on point, and that's the problem. It's not on point, but Lord, did y'all see it when it was decided? All the crazy headlines. Rail trails are dead. Rail trails will go away. Not properly, Railbank trails won't. Okay? And I know that's what they hang their hat on, and that's the one because I had one try to tell me. And I said, you do realize I'm saying that case is correct, don't you? I'm not arguing that case was wrong. You do realize, and they're dumbfounded. Well, then I can put my fence up here. Y'all can't tear my. Sorry, we're talking about eggs and chicken. Not the same thing. Okay. Anybody else have any questions?
Keith, when
John.
was that rail actually abandoned? Was that prior to?
Yes, it was prior to the Bureau of Land or Department of Interior coming in and building the parks. It was abandoned for a good long time, and the federal government, that's what I'm saying, it was insane for them.
The trail
Huh?
process,
Oh no, it was after it wasn't abandoned until 1994, if I remember what the case is. 1994.
Okay, so They went through the Surface Transportation Board,
No, that's just it. They didn't.
They did not.
for abandonment,
No.
even for abandonment.
Oh, yeah, they probably filed to abandon it and nobody picked it
And
up.
so the Rails to Trails Conservancy never really, I guess, saw that this rail was being.
Well, now, John, there's two places to file. A railroad literally can go in and say, I'm not even thinking about rail banking. I'm going for straight abandonment,
Right.
and they can go get their order. And they're relieved of any liability if they can satisfy the Surface Transportation Board.
Well, in
So I don't know if they tried it and nobody picked it up or if they just went straight. I'm just telling you, I know it was not Railbank because that was one of the things the Supreme Court said.
Yeah, in the Tyler, we had some abandonment kind of railroad issues in the Tyler area, and the railroad served papers to the Surface Transportation Board to abandon, and then the Rails to Trails Conservancy interacted to pick
Intervened.
up the trail.
Yeah. But that's the way it's supposed to work. You got 6 months from the time if you're offering it under one set, which is where you're laying down the track to go to rail banking, you got 6 months for somebody to step in and say, hey, we'll step in as the interim trail manager.
So
And the Rails Trails Conservancy picks up every one of them they find out about.
it's kind of like if you offer a public hearing and you don't come,
Nobody shows up?
nobody shows up, you miss your opportunity.
Right. Well, that's the way the rail banking law is written. There is a window of opportunity. Somebody has to say, we'll step up to the plate and we'll sign saying we're going to make it either a motorized or a non-motorized park, but it's going to be a park. It's going to be for public recreational trail use. We're going to agree to be the financially responsible party. That's the legal term. And then third, we're going to take it with the full knowledge that if the railroad ever wanted to come back in, we got a letter.
So you can't come in 10 years later and say, oh, we'd like to
Rail bank this.
that property.
No. No, and that's what the Supreme Court, from a reading of the Supreme Court case, there's no evidence they even attempted to rail bank. Okay, it was just straight abandoned. And so that's why the Supreme Court case was correctly decided. And the federal government simply, I don't know what somebody was thinking. I mean, you've got to have some gall to not even have the law behind you and say, hey, we just want to put a park here. We want to start building restrooms. We want to start putting in a campground.
You know what's happened to that trail now? You know, the family's going to...
Oh, family's going to get it. Supreme Court decided.
They're
Family's
going
getting
to
it.
close the trail?
Yeah, they have to. The federal government had no legal right to try to make it.
Talking about the families. The family going to
Yeah.
make them...
Oh, I don't know what they're going to do. I'm assuming they don't want to or they wouldn't have fought it.